is a full crowd. Hopefully everyone's here for this. This is code enforcement, just so you know, in case you're in the wrong place. We'll get started. Our goal here today, we'll introduce ourselves and who we are, and we're going to talk about our goal here today, by the way. If you think I have a burning question that I have to ask somebody who's going to give me guidance and insight on code enforcement, we're going to leave time for that. That's our goal. So we will make time for questions, but let's get started here. My name is Thomme, and I'm a prosecutor and lawyer with the law firm of Eckberg, Lammers. Eckberg, Lammers is based out of Stillwater, Minnesota. We represent 22-ish something cities of all sizes across Minnesota, both as city prosecutors as well as city attorneys. So I've been with the firm since 2014, and prior to that I was in Norfolk County for a while. So kind of seen it all, and happy to give some insights here on code enforcement, both from a criminal and civil perspective. With me is Thomme Loonan. Introduce yourself, Tom.
So I'm Tom. I'm the civil attorney in the room today. Joe and Alexis both do prosecution. I work on the civil side. Our firm does both sides, also both sides of the river on the civil side. So we represent about 12 communities in the state of Minnesota, and then we've got another roughly 10 to 13 both large and small communities in the state of Wisconsin. And so what you're going to get here today, like Joe said, is kind of a comprehensive review both from a prosecution side, from a civil side, looking at code enforcement, some of the tools that you can use, and then certainly the opportunity to ask us questions because we all work and deal in this area quite frequently, and we are not charging by the hour at this time, so it's going to be free legal. Everybody loves.
And I'm Alexis McKim. Like Joe, I'm also a city prosecutor at Eckberg, Lammers. I've been there for just shy of 2 years, but prior to that, I similarly came from Norfolk County as well. Currently, of our 22 cities, I'm largely here in the city of Minnesota as a prosecutor.
So, as you can tell, we like doing this a lot. We like talking to people about issues that cities confront, because that's what our work is. That's what we specialize in. And raise your hand here if you work in city government. Raise your hand here if you love code enforcement. Easy one. It never fails. No one likes code enforcement. We don't particularly like it in the sense of what it represents. When code issues come up, it means somebody somewhere is dealing with some problem that they can't fix. And that's what this presentation is all about. So try to give you some big picture insights and the tools that are available to fixing those problems. So what we're going to cover today, we're going to cover types of code violations, the things that you're going to get calls on in city government, the keys to compliance, and these are going to be big picture keys, big picture concepts with some specifics that a city can take to start developing a process to enforce their code, as well as the tools that you have, the specific tools that you have to enforce your code. All right, this is an easy one. You don't have to be in city government. What's the goal of every municipality when it comes to code enforcement? It's one word. Starts with a C. Compliance. Hey! In the future, they're going to make me the keynote speaker, and I'm going to have a headset and a laser light show, and I'm going to say, the goal is, and everyone's going to repeat back, compliance. It's compliance. The goal is compliance. And I put this on here as an early slide because, especially for those of you in city government, I would caution you, the goal is not punishment. Although you can prosecute people, in some cases you should, the goal is not to punish people because it's an ineffective, blunt tool that, number one, may or may not result in an effective punishment. Number two, probably won't get you any closer to compliance. This has to be the overarching value. Is it arching or arcing?
Yes.
Yes. Overarching value of code enforcement, whether you choose criminal or whether you choose civil, it is compliance. We are trying to use the tools available to us to gain compliance. So, your types of code violations, your nuisances, talking about animals. What was the one of our cities is dealing with an emotional support rooster. I didn't stay on the call for much longer after that. So, animals, trash piles, junks, accumulations, things that they're an eyesore, they smell, they look bad. Those are the things we're thinking of when we talk about nuisances. Building, your international property maintenance code or your local, the things that you say, hey, there's somebody that didn't get a permit for that, and I know that's a violation based on how it looks, based on what the code said we could do. Building also doesn't necessarily mean the actual buildings, but things inside, like an infestation. If you've ever prosecuted an infestation based on a slumlord's inability to keep, or unwillingness to keep their property clean, you know how horrible that is. Zoning, home occupation, use violations, licensing, permits, things like that. These are the general types of code violations that you're going to see when you get that call that says, hey, there's somebody in violation, you start investigating. These look familiar, anybody? I was asked, this is actual from one of the cities and one of the, I think this was the slumlord case that's referring to. It looks like a nice place. But these are the types of situations that you're going to run across and immediately draw your eye that some neighbor somewhere is going to say, that can't be legal. So, one of the questions that you'll ask, I had a conversation with Bill, I happen to work with Bill in the city of Newport. There's a balance that you're going to encounter when you enforce code. What's one of the first things people say when you tell them, hey, you're in violation of code because you got a bunch of junk on your property? What's one of the reflexive, big philosophical things they want to say? It's my property. I pay the taxes. It's my property. I can do what I want. So the reason cities take action, one of the things when you have to explain why you're taking action, to keep that in mind is there's this undercurrent that, yes, to some degree people can do what they want with their property, except when it affects the quality of life of other residents. That's something that you have to say, well, this is a quality of life thing. Your neighbors, as we'll see in a case later, when you have raw septic effluent pumping up under the ground onto your neighbor's property from a failing septic, that's a quality of life issue. Property values. I live in Como Park in St. Paul, which is a very nice, cute, adorable, cottagey little neighborhood, and my neighbor next door, 2 vulnerable adults, had their house condemned because of all the things. And here I am out planting my zinnias. Every year, I'm out there. And I feel so bad for the neighbors because they were getting on and they didn't have the help and they couldn't keep it up and it actually got condemned. We didn't sell, but had we tried to sell, that's a property value question. Somebody's gonna look and say, your house looks great. It does. But next to that, I don't think so. That's something your neighbors, your community is gonna care about. Public health and safety, again, when you've got raw septic, there's another word for it, raw septic effluent flowing up from under the ground, that's a health and safety issue. So when someone says, it's my property, yeah, but health and safety. And this one, actually, a former attorney who's now retired in my office, when we were talking about this years ago, code enforcement, he put this on here. And this is actually probably something you'll hear about more so than these first 3. Community acceptance of ordinances. When people say, why do we take action? Why are we enforcing code? House A has a violation and you don't do something. House B has a violation and you do something. What do people say?
Selective enforcement.
Selective enforcement. If you want your community to buy into the idea that we have values in this community as prescribed in code as to what types of property you can have, what things you can have, if you want people to buy in, you have to enforce it. If you don't enforce it, people don't respect it. And then it's meaningless. And you say, well, why'd you give me? It's like when we're prosecuting a speeding ticket. One of the first things people always say is, well, the other guy was going faster. Why'd you give me? Well, that's a different question. There's only one cop in one area. But the point is, people start to believe the law applies selectively. They don't respect the law. You don't have acceptance of the ordinances.
When we look at sort of the concept of code enforcement, and particularly coming at it from the civil side, the top 3, they break down into really 3 primary items, right? It's health, safety, public welfare. The top 2 can fit into the concept of public welfare. And so when your cities are going forward and when you're putting together ordinances and regulations and restrictions within the city, it's my property, my choice, but they got to comply with those laws and those rules. And when we talk about the community acceptance of ordinances, you'll hear us talk a lot today, particularly me when we're looking at the civil side, about policy and consistency. And as long as you have strong policy and consistency in enforcement, you can back up the action that the city's taken and avoid those concepts of selective enforcement, or why are you coming after me and not after my neighbor? Their property's worse. And so when we're going forward and looking at putting in implementation to enforce the city codes, the consistency really derives from the city policy and how they carry out that, and then the process, which we'll talk about in a little bit here, making sure that you're following the process that the city has adopted.
Yeah, and Tom brings up a really good point, kind of big high-level concept is when you can have your prosecutor who has some of the tools and also have your city attorney, your civil city attorney also saying, before we get to any problems, let's make sure we've got a process in place. And let's say, we're going to talk about ordinances and good, clear regulation. Having those two partners work together is a really big deal. It makes code enforcement that much simpler, easier. So, good point there. So this is the infestation, by the way. I'm pretty sure that's where the cockroaches were coming in, but, so your keys to compliance. Keys to compliance, these are the three big concepts. Number one, process. Process, process. You have to have a process. You have to have a process. Documentation. I think like a prosecutor. When people say what tools do we have, one of them is criminal prosecution, you have to have documentation and evidence that we can use as it filters down to the rules of evidence and criminal procedure and like a trial. You have to have evidence that we can use to make the tools work. And then you have to give notice and take action. I know that's technically 4, but I have this rule of 3, you'll remember it better. Process, documentation, notice and action. Those are the 3 keys to compliance for whether it's whatever tool you choose, those are going to be the keys to your compliance. So, process. There you go.
So yeah, we had talked about clear regulations. Making sure that the regulations that you're putting into place, the restrictions that you're adopting for properties are clear and concise and easy to follow. We run into situations when we have ambiguous ordinances where you will get a scrupulous homeowner or an attorney on the other side that can push through that. Recently, we dealt with that in the city of Hudson. Some of you may have heard or seen in the news that the city of Hudson is now the proud home of a very, very bright pink house in its downtown historical area.
It's really cool up here.
It's an old historical mansion. It's beautiful. It looked phenomenal. But the owner that bought it, she wanted to go pink. And she was adamant to the city that I'm going to paint this home in the historical district bright pink. And the city said, you can't do that. It violates our zoning code because in the historical district, you have to use earth tones. Her first argument to the city was, well, if you don't let me paint this house hot pink, I'm going to suffer monetary damages. Because the Barbie movie is about to come out, and if I don't get this house hot pink before the Barbie movie comes out, I'm missing an excellent financial opportunity. I kid you not, that's the argument she made to the city council. The city council said, we don't care about the Barbie movie, you can't paint this house in the historical district hot pink, it is against our ordinance, earth tones only. Well, then she got an attorney involved, and the attorney started looking at it, and he said, yes, we can paint this house hot pink. The city says, no, earth tones only. He says, well, if you don't let us paint this hot pink, I'm going to take it to court, and I'm going to bring a geologist in who's going to tell you that pink is an earth tone, and therefore we are allowed to paint it hot pink. The city evaluated, cost-benefit analysis, ultimately backed off on the fight. We now have a hot pink house in downtown historic Hudson, which you can rent on VRBO if you're looking for a fun getaway with you and about 13 or 14 of your friends. But ultimately, that was a matter where the ordinance, the intention of the ordinance, the purpose of the ordinance was correct. They knew they wanted to preserve this district. They put in regulations, design standards, which they thought were reasonable, but ultimately the ambiguity of earth tones allowed an opening for this individual to then expose that and push forward on a hot pink house where ultimately the city didn't push forward on enforcement. So that's an extreme example, but a matter of making sure that these ordinances that you're putting into place are not ambiguous, that they are not discriminating against certain properties over another. Again, under your zoning code, you can put these in as long as you're treating similarly situated properties similar and the characteristics are equally applied across the board. But that's where you work with your city attorneys, you work with the individuals to make sure that you've got tight ordinances that can be enforced when they need to be enforced.
Tom, is the answer on that just spitballing, is it define earth tones? Could they have gone through and said, these are the colors we need?
Yeah, you can go through, you can put that together, you can refer to different, different policies and such that the city's adopting with regards to those design standards. The design standards, they can't be overly restrictive, but something, especially in the historical district, which are often given more protections, you can put some of those requirements in place, and individuals have to be complying with those. And in this instance, it just wasn't, the clarity wasn't there, the specificity wasn't there, it allowed for the loophole.
So yeah, the first is clear regulations, and the second one, this is tough. Some cities have the staff, some cities don't have the staff. We have some cities where it turns out it's the city administrator. Are you any city administrators here? I was going to say there's a new code enforcement official. But designating a code enforcement official who is going to go ahead and take complaints. This is the person that it's going to come to. Anyone here on city council besides Bill? All right. You're going to get calls. You're going to get calls. People are going to say, hey, come out and take a look. Come view. And you know what we call you now when you do that in criminal court? A witness. A witness. So if you go out and view a code violation, and I guarantee they're going to know it's you. They'll say, hey, that's a city council person. I probably now have to bring you as a witness to court. So just remember, it's always better when you get those calls to have somebody to turn it over to say, my code enforcement official, whoever that is, you don't have to necessarily call it that. That's going to be the person who's going to observe those violations, take those complaints, be the witness in the event that there is some sort of action where we need testimony. The last one, and Tom, this is more of a civil thing, but the search warrant piece, that's somebody who's going to do the search warrants, the administrative search warrants.
Well, and it's interesting that you mentioned this as a civil thing, because I think most people think of a search warrant in a criminal context. You're getting a search warrant, you're going out, you're looking for that criminal violation, having a judge sign off on it. But what a lot of people don't realize, what cities maybe don't notice, people new to city government, is that there is a process through civil remedy where you can go forward to a judge and do that same process and get what's called an administrative search warrant. And the administrative search warrant is when you find a violation of your well-written regulations. You say, we've got witnesses, we've got evidence, we need a search warrant, we need to go look at this property. At the end of the day, we are acting on behalf of the government. Because we are acting on behalf of the government, we are bound by the Constitution. Civil or criminal, the Constitution applies. Particularly in this context, the 4th and 14th Amendment. So unlawful search and seizure. Even if all we're doing is a civil remedy, all we're doing is trying to stop somebody from violating code and trying to just get them to come into compliance, we're still bound by the Constitution, and that individual is still entitled to due process. So when we're going through the motions, when we talk about the importance of process, we're talking about preserving and protecting the procedures that you go forward with to make sure that they're going to be enforceable. Because if you don't go through the proper steps, if you have a city employee that goes out to a house, doesn't have any permission to be there, doesn't see anybody at the house, goes ahead and walks around to the backyard to see what kind of nuisance they're maintaining back there, and then goes forward, writes up the complaint, and pushes that forward without any consent, without any warrant, the judge is going to throw that out because you haven't complied with their due process. You haven't gone through the procedures. So when your code enforcement officer or any individual on behalf of the city is going to investigate a potential violation, they're entitled to observe from the street. They're entitled to observe from neighboring properties so long as the neighboring property has invited them on. They are not entitled to go on to the violating property unless they either have clear consent from the owner or the individual in control of the house. So if there's a tenant there, they can give them consent to enter, or they have the administrative search warrant. And so that's a kind of a big piece that sometimes I think people get gung-ho, cities get gung-ho, they want to go forward, they want to get that violation, but you have to go through the process. You have to make sure that you either have the consent to enter or you have the administrative search warrant. Administrative search warrants aren't particularly difficult to get. They don't particularly take a lot of time to get, but they are a very important part of the process to make sure that any enforcement that you achieve through the courts is going to be upheld.
One piece on that, and this is such a nuanced thing, but it literally just happened the other day. it's worth telling you. What Tom just described is the process. We can impress upon you, no other no exceptions fact, is the process for violations, either observed from the street, neighboring property with consent, consent of the owner that you're trying to investigate, or a warrant, period. However, we have people from all over Minnesota, which means you have a wide variety of judges. There are 3 sources of law in the United States: the Constitution, state law, or what a given district court judge says the law is. I am going to tell you that even if you get a judge who resides in the community where the violation that you're trying to remedy exists, and that judge believes that they have the authority to order in a criminal case without criminal conviction or any other authority to just search a property, I'm going to tell you that is not going to be constitutional. We had this happen the other day. They called me and said, hey, the judge ordered in the criminal case. I said, you mean the one that just got filed? Yeah. He ordered search of the property. I said, I'm no judge, but he can't do that. I said, don't do that. Don't do that. It will not be upheld. Whatever you bring out of there, that will be an unlawful search. You say, well, the judge ordered it. Yeah, the judge didn't have authority to order it. That will be flipped on appeal. So, Tom's description there on the search warrants, I know it's a little end piece. That's a big one. Those are the ways you can search or view or gain evidence: is search warrant, consent to the owner, consent to the neighbor, or from the street. That's it.
With one exception.
Classic lawyers.
If there is an emergency, and generally an emergency is going to be something related to health or safety that needs to be dealt with right away, you do not necessarily need to obtain the warrant. If there is an emergency. Now, those instances are going to be kind of like one of those things one judge said, well, what is pornography? Well, you know it when you see it. An emergency is something, you know it when it's happening. I still emphasize contacting, getting quickly a hold of your city attorney, saying, here's what's going on, can I get on there? We need to either right away stop this because there's a health or safety, concern here, or, we need to get on it right away. There's an immediate concern. In emergency situations, and they're not specifically defined, again, it's kind of one of those things where you know it when you come across it. You don't have to go through the search warrant. You can enter the property, but when you run into those types of situations, again, I emphasize contacting your city attorney, say, here's what's going on, can we go, can we get on the property, are we going to get in trouble? There's a health and safety issue to be taken into account.
And to that point, if there is an emergency, you should call your police as well. Generally speaking, police departments don't love code enforcement, but if you call them and say, hey, there's a very emergent issue, having somebody stand by on scene while you do it is a good idea as well. Your designated code enforcement official is going to take complaints, observe violations, get those search warrants, identify. Yes, sir.
In the historic preservation context, does an emergency include the degradation of a historic resource?
Whew, that's a good one. I don't know if I know the answer to that. Degrading a historic resource.
I mean, I guess it depends on what you describe as degradation. I mean, if they're tearing it down, there should be building permits. They should have gone through a process, so you can halt it on that grounds, right? You can say, hey, you didn't get the proper permits to go forward with this, so it should have stopped earlier on. If there's someone out there vandalizing, obviously now we've got a criminal situation, we don't have a code enforcement situation. So I guess if they just don't talk to the city and go and start painting the house pink, you could potentially go out there and say, you need to stop right now, and we'll talk in a little bit about restraining orders, and then we also have these things, emergency temporary restraining orders that kind of speed through due process and have the courts put a stop on things right away.
Just to preserve.
I would think in those instances, to maintain the status quo, you could go out there and probably stop it and just say, because you are going to do irreparable damage to this property unless we stop it right now. Then we'll figure out whether or not what you're doing is allowed or is not allowed. But in order to stop irreparable harm, you generally could step in and stop it. If it's something that you're not going to be able to fix later on, that needs to be immediately halted.
So maybe use your stop work order authority first, but then if you need to, go and try and get...
Big time in most instances of a degradation of historical property, stop work order is going to be the preferred method. That's the best way to go forward. Again, there should have been a process they would have gone through to get those permits, the approvals of what they're going to be doing. But if it's just painting, then that doesn't come involved. So then it's like, okay, we got to get out there. Well, the counter argument is we can just repaint it, but that becomes a tricky situation as well.
Identifying specific code section violation violated. That's an important one too. You need to have somebody who is going to know what the violation is. I know it seems obvious, but a lot of times the process right now, if you call the police, again, we need buy-in from your investigator. Your cop goes out, doesn't know what specific zoning code or building code, other than maybe an obvious nuisance. They don't know what it is. And so what do? Well, here's a ticket. Or maybe not a ticket. Or they don't do anything. They don't say anything. They just say, this is what I observed. I don't know what to do with it. You need somebody who's with them that says, here's the problem. Clearly those windows are leaking. That's a violation of whatever. Or clearly there is some sort of infestation going on here. Or this person doesn't have a permit for that action. You need to have that person. Because again, similarly, my witness is going to come to court and have to answer those types of questions to a judge or a jury and explain why there's a violation because they're familiar with the code. Document violations. This includes photographs, written descriptions, dates and names. This is not just some of those. If you're going to take evidence, if you're going to take pictures, you need to be able to tell me when you took
Basis for enforcing the violation. And so again, the process is important, going back to the concept of due process. You need to make sure that you're putting together a clean and tight record so that when you bring that forward, whether it's going forward through the city council, whether it's going forward through the court, you have a tight record to establish that there is a violation and get the order that you need to go ahead and bring that violation into compliance.
Identifying and maintaining a record system. Does anyone have a record system they use for code violations right now? What do you use? What is it? Track it? Yeah, I haven't heard of that one. Permit work, you still use that?
Energo.
What is it?
Energo.
Energo? Whatever it is, there's a lot of, lawyers have their own case file management. Whatever it is, coming up with a system. So for instance, complaint received this day, property owner. And again, sometimes that's going to be really important. Who's the owner? So how you figured out who the owner was. Date violations observed. Date letter sent. Follow-up date. All of those things are going to be really important. As we'll talk about shortly, with criminal enforcement, being able to educate judges why, when they've got a backlog of cases, why if they have domestic abuse or horrible crimes on the calendar, they suddenly have a code enforcement case. Why that case is important too? All those details matter. All those details are going to be really important. So, documentation. Your code enforcement officer is going to document and record those violations, those sections violated, including all those things we just talked about. Communications with the owner and violator. Communications with the owner, that's a defendant. So if it's a criminal case, why is that important, Alexis?
Any communications with the owner would be admissible in court from that code enforcement officer. So when they come in to testify, any admissions that they made, any statements they made, we can use that against them in court.
So a lot of times these people, I shouldn't say these people, your constituents who have violated city code, a lot of times they're going to have their own opinions. Remember we talked about that tension, that philosophical tension. It's my property versus what the community wants. You're going to have that. They're going to say a lot of stuff. And so, but writing that down and saying, the owner said this to me, I can do what I want with my property. That's pretty good evidence. I can go run in front of a judge or a jury and say, they don't care what the code is. That's pretty close to admitting they're guilty. CEO is going to maintain that record system.
So I just want to kind of, looking here and at the process concept, I think one other thing that's important to emphasize is, I know we have people from various community sizes, big and small, but part of the process, part of the documentation is really, how does this get started? And there's two primary ways that cities will go forward with how they're going to do code enforcement. They either go on having the CEO, the code enforcement officer, do rounds, different neighborhoods, throughout the year, checking out, making sure people are okay. But the primary thing that we see, particularly in smaller communities that don't have the resource of just a code enforcement officer to be driving around town, is complaint-based. And so, again, when we talk about policy, when we talk about procedure, making sure that you're kind of honoring the process of how do these go forward. Certainly if a city official observes a violation, you want to be notifying about that, but a lot of cities are on that complaint-based method. And when we talk about communications with the owner violator, also communication with the complainant. Now complaints may come in anonymous, they're certainly allowed to come in anonymous, But sometimes you'll know who the complainant is, you want to talk to them as well, figure out what's going on there, and then follow up on it. Because again, going back to this concept of selective compliance, well, selective compliance, if you truly are engaged in selective compliance, and you're truly in a situation where you are violating somebody and not violating another person who's doing the exact same thing, you may run into an equal protection claim, you may get into trouble under the Constitution. Very, very rare, but again, that policy and process, and from the very beginning of how does this come up, if it's complaint-based, do we follow up with the complainant, when do we substantiate that complaint, move forward, determine what we're going to be doing on it. But give consideration within your own cities as to how you are beginning this process. Where does it start? Is it observing from city employees? Is it complaint coming in? Is it a mix of the two? Just understand that, keep that in mind, because if there's a complainant involved, you're wanting to talk to them as well, because they may need to come and speak to what they've observed or what they're aware of.
And in a criminal context.
Yeah, it's incredibly important.
I can
to
see
document.
Alexis itching.
In a criminal context in particular, documenting those initial reports is hugely important. Getting contact information for that complainant, their name, their address, their phone number, they're potentially making themselves a witness by coming forward as well. So when it comes to a criminal prosecution case, we're probably going to want that person in addition to the code enforcement officer about what their initial observations were, what they did, what they saw. So if it's anonymous, that's okay. If it's not, that's better. And if it's not, it's absolutely important that that information gets documented and provided to the city attorney with that case referral.
Well, I think it is okay, but just know that when we'll get to this, choosing which tool you're going to use. If you have an anonymous complainant, one of the ways we get around that and still go forward if you choose a criminal code enforcement, so prosecution, is who's going to be your witness? Your code enforcement official. You get an anonymous complainant that says, hey, just so you know, 123 Main Street is a violation. If we don't do anything else, that anonymous witness, we can't use them because there's this thing called the right to confront your witnesses in a criminal case. So if you have a code enforcement official who then says, oh, by the way, I drove by and I observed and confirmed there were violations, we maybe don't necessarily need that anonymous witness anymore because we've got a different witness to use. All the more reason to designate a person, not a city council person. Yes, sir.
Just a quick question about that documentation. Is that considered public record? As a hypothetical, say that the applicant or the person wanted to submit a Freedom of Information Act, would that be considered public records?
So I'm going to rephrase the question so you can hear, and then I'm going to let the city attorney who does data practices answer that question. The question was, if somebody makes that complaint, is that public record? Can someone file a data practices request or a Freedom of Information Act request? Is that public record?
Yeah, so it depends on the status of the enforcement. Because if you're into an active investigation, you're going through the process, you can generally protect that under the Data Practices Act 13D and hold it back until the investigation has closed or until that's filed with the court. The individual who has made the complaint, because this question comes forward a lot, who told on me? Who called on me?
Yeah.
The individual who made the complaint is not generally going to be public data unless they make themselves available to public data. So identifying the individual, generally speaking, is not going to be a public data. The complaint itself, again, status of investigation, status of enforcement, likely will be public at some point, but perhaps not right away. In each instance where you get those requests, again, you're going to want to talk with your city attorney because anybody who deals with the Data Practices Act knows there's a million different little nooks that you got to be looking at and thinking about, and particularly when you have an enforcement action, when you're looking at court and due process and preservation of evidence, all that's going to come into play in determining what you can, what you can't, and what you're absolutely required to be releasing out to the public out there. So, great question, and something, again, emphasize checking in with your city attorneys, but the answer is eventually yes, complainant generally no, and that's kind of how that goes forward. And then, quickly, before we move on to this, one more thing that I want to emphasize, because I don't think we'll get into it later, is how many of you take calls, complaints from citizens about issues with properties?
Did like everybody, right?
The other important thing to remember to keep in mind is public nuisance, private nuisance. Government has no obligation, city has no obligation, nor do they have any right to enforce a private nuisance. At least once a month, I have one of my cities call me saying, we got a complaint about this issue. They want us to go through a nuisance, they want us to get enforcement, and we review it. We said, that's a private matter, that is between neighbors, they've got to deal with it.
So like an example of a private nuisance.
So I had one just the other day where there's a dispute between two neighbors. It was a property line dispute that they resolved the property line dispute, but they were now on contentious terms, and the property line kind of jutted into the corner of the neighbor's backyard. Well, neighbor number one, who acquired additional property in the neighbor's backyard, was upset, and they started putting stuff out into the backyard and storing it back there, and it was, innocuous stuff. It was a hammock, it was a hockey goal, it was stuff, but they were clearly storing it right in the eyesight of this neighbor to piss them off. And it worked, because the neighbor called me not at least 3 different times, and I talked to her for a good 2 hours about this being a public nuisance. The city needs to come out here and enforce. So finally I said, I've seen the pictures you've sent me. She goes, isn't that egregious? I said, absolutely not. That's their yard. They can store stuff in their yard. That is not a nuisance that's rightly stored. But she goes, it's affecting my property value. I could never sell my house with this hockey goal and this hammock and this piece of wood in the backyard. So I went out and looked at it, and I looked at it, I told her, well, you may have a claim of the individual neighbor affecting your property value. You may have a nuisance claim if they're hurting you, but this is not a public concern. This is a private concern. Sometimes we deal with it with landscaping, trees as they're overgrowing, and they'll say, well, you got to come out and cut this down. It cuts into my yard. That's a private nuisance. That's between private individuals. And I guarantee you, any of you have received calls from individuals, you've received calls from neighbors who are just trying to get each other. Oftentimes, those neighbor calls are just going to be private nuisance. And I know these guys can talk about it from a criminal context, and we can talk about it from a city attorney on the civil side context. We want to leave those matters to the private individuals. We don't get involved in neighborly disputes. We are looking out for the good of the public. We are looking out for the good of the city. We are not advocating for one individual owner just because they're mad at their neighbor.
Well, this is perhaps that good tie-in as well to the, when we say clear regulations at the outset, that's also talking about clear values. So the only way I hear that those turn into enforceable actions is if there's a code that says, well, we got so down deep into the weeds, literally, that we said you can't store hockey goals. So that's a code violation? Well, okay, maybe it's an enforcement action now. But when you talk about regulations, clear regulations, these are big, broad, value-based statements. We don't want trash accumulating on properties. We don't want infestations. We don't want failing septic systems. Those are the things that your code is going to concern itself with. And if it doesn't concern the code and it doesn't concern the public, it's going to be neighbor-to-neighbor dispute, which, by the way, ask me how I know. Those are so fun in court. They're so fun.
And don't be afraid to push it onto the individual and say, hey, that's a neighbor dispute. You got to find your own attorney. And then let their attorney come back and tell you, no, this is a public dispute. Well, then, maybe not. But if it's looking private, don't be afraid to push back on it and say, this is a private dispute. This is between you and your neighbor. You guys got to sort it out. If you want it resolved, you're going to have to go and retain your own attorney and work through it. All right.
So on this one, for those of you that are going to go back to your cities and you're going to say, we need to overhaul our process. We've got problem properties in mind that we need to start taking action on. Let's come up with a process. Let's do it. You guys are about to enter the most difficult phase of code enforcement. Because your problem properties, your entrenched issues that have been there for so long, unfortunately, at least half the problem is due to inconsistent, to Tom's point, inconsistent enforcement. Who here has a city that has an administrative penalties schedule? Right. Somebody has a violation, you send them a piece of paper that says you owe us money. What happens if they don't do it? It's like $25, $50, now it's $100. I literally asked this to Tom yesterday because I was like, I guess I don't know what happens. He's like, well, we could assess it, but it's going to depend on if the city wants to. Right. So now you've given a piece of paper that says, don't do this again, pay us money. If they pay you money, great, you have $25, but you still have a problem. If they don't pay you money, you can now assess it. Now you're chasing the bill that you just created. It's not terribly effective. But meanwhile, what's happening? That person, it's like adult parenting. That person has been told, stop doing that. Or what? And we don't do anything. Okay, so what happens the fifth time that happens? How deep are those roots of the problem getting? Very entrenched. So now the notice and action part. You've got a problem. You've identified it. You've documented it. You think you can do something with it. It's the this is where it all has to work. It has to be consistent. There cannot be deviation from it. Cannot be deviation from it. You have to decide. Notification. You have to tell them. These are the violations in writing. I observed, and I'm a big fan of short letters. I know I talk a lot. Short letters. On this day, the following violations were observed on your property. Code violation 1, 2, 3. Boom, boom, boom. And specific descriptions that say this was a violation observed. Giving them a timeline for compliance. Cities got to decide what they can tolerate. It's going to depend on the type of violations. One of our cities has fire code violations, up and down, left and right. It's going to require the building to be torn down. If you gave them 14 days to deal with it, are they going to deal with it? No, they're not going to tear down the property. That's pretty unreasonable to begin with. What they may say is give me more time. And so you can develop within those timelines. You can say at day 14, if we see substantial compliance, talk to your city attorney about what phrasing you want to use. Substantial progress, substantial attempts for compliance or cooperate, whatever it is, you can say, okay, we will extend that by this. But you have to follow those timelines. And you also have to put a promise up. Promises are only good as if they're kept, right? So you have to put a promise up. If you don't do this, X will follow. And then you got to take action. That means following up, reviewing the property, telling them, I'll be back, 2 weeks, I'll be back. And you either show up with a warrant that says we're searching the property, or if it's observable from the road, you observe it from the road. I will be back. You have to follow this process every single time for the same violation. For all the reasons we've talked about. The people that, well, you're not doing this to my neighbor, you're only doing it to me, you have to do it every single time. And built in this timeline piece, it's going to start talking about criminal here shortly, but built into that timeline piece, if you've got a violation that can only be remedied by a tear down, we've got a neighbor in one of our cities, it's one of those cities that's kind of a mix. It's right on the northern ring of suburbs and then rural. So you've got this clash of values. People want to do whatever they want. Some people don't. Somebody built this huge addition on their house and they're renting it out. The city, I asked her, so what's the goal here? They said, well, we want them to tear down the house. There's no criminal judge. In a criminal case that's going to say you charged a misdemeanor, your sentence is tear down half of your house. That's going to tell you, if my timeline can't be completed, if the compliance can't be completed in the timeline I'm giving, one of your tools probably isn't going to be very good. That's criminal court, because the end result in criminal court is hopefully a sentence, a criminal sentence that requires compliance. Just keep that in mind when you start to develop your timeline is what am I reasonably expecting people to do, and can that be obtained? And then following up with your legal enforcement, which action. So let's talk about your civil tools. Oh, first one, I did that out of order. So what's your first one there, Tom?
Yeah, so your first and honestly your most effective and certainly your most cost-effective tool is voluntary compliance. Never contribute to malice what can be explained away with ignorance. People may just not know that they're in violation. And a well-worded letter explaining the violation, requesting they come into compliance, without any penalty, maybe a little threat in there, is generally the most effective means. People generally will bring their properties into compliance, even if they're doing it on purpose. They may have just gotten away with it. Finally, the letter goes out, and they say, all right, I got to fix this. And one big one that we see in our communities is parking vehicles on an impervious surface. Because they just got too many vehicles, and particularly in Minnesota in the wintertime, can't park on the street, so just drive it up onto the yard. Put it up to the side. People will do that and do that and do that until they get caught. Send them a letter, say, you can't do this anymore, fix it. Oftentimes, they fix it. Not every time, but oftentimes. So that voluntary compliance, again, the goal is compliance, the goal is not punishment. Notify them of the offense, give them opportunity to cure it. Civil tools. Civil tools can be through court process or through council process, but the important thing is process. Due process, constitutional rights. We've got abatements, injunctions, TROs, temporary restraining orders, and then we'll talk a little bit about hazardous building designations. This is statutory. This is an extreme remedy. This is like what Joe talked about. Oftentimes a hazardous building designation, if you go through the entire process, get the designation, the end result will be that they have to tear the property down. And that is a right when that hazard exists because, again, we're talking about the extreme concerns of health and safety with those hazardous building designations. We'll go into these in a little bit. The other process is criminal prosecution tools.
Criminal prosecution tools basically comes down to the threat of charging them. So you can issue a citation on your misdemeanor, or if it's a little bit more complicated, needs an attorney review, you can send it to your city prosecutor for a formal complaint, basically charge them for the ordinance violation, bring them into court that way.
All right, so civil remedy. We'll start at the first one that we had listed out there, which is the abatements. So an abatement is basically an order telling somebody to not do something, to fix something. It's an order that you can get. Again, you can do the abatement process through your city council, assuming that your ordinances are written properly, or you can go through the court. In either way, you gotta honor the due process and go through it. And so generally, the timeline that we're looking at is 90 days to a year, allowing opportunity, amount of time to comply with the order. The process that you're going to go through. So you're going to put together the complaint. We talked earlier about getting the documentation, building the evidence, putting together that complaint so that you have a tight record to bring forward. You have to allow the individual an opportunity to be heard. That is due process. They need a chance to refute and argue against the charges that the government is bringing against them. Again, the complaint can go through the council, as long as your ordinances allow for it, or you can bring this into court. Most people prefer the latter because then, the former, because then they can, the process goes quicker. You don't have to wait for the court schedule. You can work it through. The council in those instances, or some sort of zoning authority that you've established, sits as judge. And your code enforcement officer presents the case. They say, this is a violation. We want to issue a fine. We will stay the fine. We'll hold it back. We want them to cure it 30 days, 60 days, whatever is reasonable. Council sits in that judge, that quasi-judicial role. I'm sure any of you who sat at a council meeting heard quasi-judicial. You're acting as the judge. You look at the facts, you apply the law, and you determine what the order is going to be. The individual who's in violation has an opportunity to state their defense. They get the opportunity to be heard, say, I didn't violate, here's why, or here's why I'm entitled to an exception, or here's what I get. Council makes a decision, abatement, clean it up, fix it in 30 days, or you're going to be issued a fine. Like Joe said, fines oftentimes are not very effective, but if you're getting to this point, you're ready to go forward anyway with the court process. The individual will have an opportunity to appeal. They can appeal it up to district court, then you go through the process just as you would right from the beginning. Again, you can assess costs onto the property. If the other remedy on abatement is you say, you fix it within 30 days, you fix it within 60 days, or we will fix it. And when we fix it, every cost that we incur fixing it is going to be charged onto your property, and we'll get the money either way. So you choose what you want to do. You want to be in charge, or do you want the city to be in charge? Because we're happy to send a group out there, fix it, get it taken care of, and send you the bill. And if you don't pay that bill, it'll just attach. We'll collect it through taxes, or we'll collect it, hold it on the home, and we'll get it over time through the assessment process. Other civil remedy. This is a court process. This is the idea of an injunction or a temporary restraining order. Generally, they are the same thing. Timeline, again, 90 days to a year. Here you are on the court calendar. Here you do rely on the amount of time it's going to take you to get in front of a judge and then have that judge issue an order. The temporary restraining orders go a lot faster than the injunction because, again, those are generally occurring in emergency situations. They're going to look at a couple different things. They're going to look at the strength of your case. They're going to look at and say, if we don't stop this immediately, is there going to be irreparable harm? Is there going to be damages occurring that will not be able to be fixed later? They'll get that TRO in place. They'll finish out the process. Generally, people will come into compliance if they lose on this TRO action. So the process, similarly here, you're going through the court. You're working with your city attorney, putting together the complaint, getting those exhibits, getting those witnesses, building the case, serving that out, notifying the owner. Notifying the owner. It is the owner of the property that is in violation. If there is a tenant on the property, that tenant is not the violator. It is the property itself, therefore you are going after the owner of the property. I just had an instance last week. I was up at a council, a staff meeting for one of my cities up North Metro, and they were chuckling, telling me about this situation that they had where an individual had called in a code violation because there was a work truck that kept parking out in the area that there was a no parking allowed. And it was right out in front of his property, and they wanted them to stop parking. And they had talked to the individual, and they wouldn't move the truck, So finally, our zoning administrator, who was also our code enforcement officer, put together a notice, sent out a notice to the property owner. The complainant was the property owner. He complained about his tenant who kept parking the truck, and the guy was mad. He came into City Hall so ticked off saying, "Why did I get this? I wanted the violation issued. He's parking the truck out here. You got to issue the violation." I did issue the violation. The violation's on the property. Well, who gave the complaint? He goes, "You did. Your complaint." And so it worked out pretty well. The guy was able to work with his tenant, but he understood at that time it is the property that is in violation, therefore the owner of the property that you're going to be seeking your relief after. Generally, again, the court is going to issue, if you go this process, the court is going to issue an order. Now you have a court order. Court order is a lot stronger than city council, making an issue. City council can collect costs. Court order will say cure it, fix it in 30 days, 60 days, 90 days, whatever it is. And if that individual does not cure it within that time frame, now they are in contempt of court. They are in contempt of a court order that can carry significant fines enforced by the court, more strictly than the city can enforce them, or it can carry jail time. You can be held in jail for contempt of court, and sometimes it can be so strict that they'll say, "We're going to put you in jail until this gets cured out, so figure it out." Courts are very lenient. They give a lot of time to fix these things, but stubborn individuals just sometimes will not do it.
And before we go to the next one thing to keep in mind, Tom talked about the owner on violations, the owner of the property. Think of it as a leverage situation. Okay, I've done both criminal and civil code enforcement actions in the courts, and you get the attention of a lot of people, especially if you've got a violation that's on the property that the owner might not know about, the tenant might know, and suddenly that person gets a complaint that says, "Here's a court order shutting off your water because of your septic system." And I use that example because that's the one we're going to talk about. Suddenly action starts happening. You're putting pressure in the right places. The people who own that property are now being told you can't use your property in a certain way, or you're going to start facing enforcement actions, fines, fees, etc. Things start happening really quickly. So that's a part where you have to have a city attorney who's involved to help you decide which is the right tool, where do we put the pressure, and usually you can find somebody who some movement will happen if you're selective and choose the right tool.
So quickly, in summary on the civil remedy, oftentimes it's going to be a more timely, a quicker result, particularly if you go that abatement route through the council. It can be cost effective, again, particularly if you go through abatement, and it can be a more comprehensive result because you can order and say fix it, or we'll send somebody out to fix it, we'll charge that back against you, it could work through it. And I encourage you, if you get past the voluntary compliance phase and you can't work it out, certainly be working with your city attorneys, looking at how you're going to build that case, how you're going to bring that case forward to ensure that you're following the proper procedures, because again, those due process concerns are always looming for these sorts of violations. But before we jump over to prosecution, because prosecution won't talk about voluntary, civil, we're very civil. Voluntary compliance is always the best result. So make sure you have good letters, that you send those out, that you put people on notice, give them the opportunity to cure before you start incurring costs, stress, and time in trying to get these violations solved through legal process.
I just have a quick question. So, in an instance where a property owner, let's say they have a bunch of stuff, old cars and junk, and they're telling you they're working on it, but finances are an issue for them. They can't hire somebody, they don't have the money to hire a tow truck to tow something away or fix it. In an instance like that, if the city agrees to assist them with the removal of something. And you need to bill them, as a city then, for that service, you bill them, they're not able to pay, you put that on their property tax?
Yeah, generally you would do that as an assessment to the property, and then recover the cost over time.
Okay.
It does get a difficult situation because sometimes these property owners are in a position where they can't cure right away, or they don't have the means to cure, and the city wants compliance, and it depends on the kindness of the city council as to how they're going to work with an individual. But yeah, there are times where they say, hey, we'll stretch this out over a period of time, we'll send somebody out to abate it, and then we'll collect it over 10 years or something, and then if they go to sell the property, if there's a foreclosure or something, you can then collect on that end. But yeah, that's a remedy. It attaches to the property similar to like a lien would, and then you can collect it year over year on those properties. Yep.
Okay, thanks.
All right, your other tool for enforcement is criminal prosecution. Generally, for code enforcement, criminal prosecution is essentially your tool of last resort. You've tried voluntary compliance, that didn't work, your civil remedies aren't working anymore, so it's generally a last-ditch effort of, hey, if you don't comply, you can go to jail. The idea of the goal here being compliance and not punishment, we can still try and go the compliance route with a criminal, but the reason I think it tends to be effective is because people are generally scared into that compliance. They don't.
We've decided that's the tool we want. And you're gonna hear us talk a lot about cost between civil and criminal, because I think a lot of cities send it to their prosecutor because we can crank out a complaint in 5 minutes. And they think it's cheaper. Might not be more effective. And so I think I would just put a pin in this concept of what you're doing when you get to criminal prosecution is we're threatening people in a legal way to go to jail, to have a criminal record, to be on probation. But if they don't, that doesn't spook them. So if you've got a trashy property with a guy with a criminal record, a history who's probably on probation already, criminal prosecution isn't going to scare him into doing anything. He's going to say, bring me to court. I got nothing to do, bring me to court. So remembering that, number one, when you pick in your ordinance, should this be a payable petty misdemeanor, meaning they can just pay it, it's just a fine. Remember, fines aren't always that effective. Or you're choosing, we're going to make this a misdemeanor. We have to remember that if we then choose that, we're going to threaten this person with violating a misdemeanor code, bring him to court, criminal court, threaten him with jail. That whole process, the quiet part out loud, only works if they believe it. They say, I'm scared, I don't want to go to jail. And to Tom's point, voluntary compliance, there might be people that are like, oh my God, I didn't know this went that quick. And those good people, do you really want to create a public criminal complaint that says their name if they're just going to be spooked into violating or complying? You'll get compliance, but man, you've now created a criminal record or a complaint record, or God forbid, an arrest record for somebody that really just needed to have a good conversation from their city code enforcement official. So, back one, this last one too. This piece, normally you're gonna hear lawyers trying to slough off work and say, don't send it to me. You might see this hot potato game sometimes if you have city attorneys that are not from the same office. We desperately try to avoid that, but it's not as simple as go issue a citation. Because remember, we are right now coming out of a pandemic that in 2020, they stopped processing cases for like 7 months, statewide. So you now have a huge backlog of cases. And you're gonna now create a citation that gets thrown in the mix with your traffic tickets, your theft tickets, your domestic assault tickets, your felonies, everything else. And we're gonna say, hey judge, but us too. The only way we often get there, this is about creating more work for us, is your prosecutor. You're gonna choose criminal code enforcement. I say if, because it can be effective. It's not the most effective usually. You're gonna ask me to draft a complaint that lists out, remember back to our process and documentation, who observed what? How long has this problem been going on? How long has it been a nuisance to their neighbors? How many chances have we given them? You need to educate your judge to say, Judge, this is important. This is a quality of life. This is a quality of life issue. There's a limit to that. Because remember, if we're talking about stuff that's so emergent, so important, so we need to get attention, but we chose the criminal prosecution tool, which might not get us a first court appearance for 3 months, kind of undercuts your argument that it's that important. That might be your TRO, where we need action now. That's why we went and did that. That might be your stop work order. We need action now. So That's just something to remember when you're choosing criminal code enforcement. It depends on will this threat work and are we educating the judge? And that's usually by complaint, not by citation.
But those are the first route to criminal prosecution to get things started would be to issue that citation or refer it up for a formal complaint. Synonymous, different documents, different information, but same result of starting that criminal process, starting that criminal case, making that public record of a criminal charge. So the criminal prosecution process is filing that charging document, and then it goes into the court process and gets put on a court calendar for arraignment. As Joe said, that can take up to 3 months to come in for a first appearance. Generally at an arraignment, a person is informed of the criminal charges against them and their rights in the criminal case and the general overview of how that process works, and it makes a determination of whether or not they want to apply for a public defender, retain an attorney, or represent themselves in the proceeding. From there, it gets set out to a future court hearing, a pretrial hearing, where they can decide. Again, generally people in these situations are still trying to determine, do I have the money for a lawyer? Do I need a public defender? And we're trying in the back end to work with that code enforcement official to try and continue to gain that compliance and say, hey, you have a court date coming up. That's kind of your timeline now. How much progress can you make before that pretrial so we can talk about ways to negotiate a resolution and gain some compliance through the idea of before your next court date, what can you get done? What will that do for your options for pleading guilty, keeping this off the conviction off your record, and things like that. At the pretrial hearing, they can raise any issues, say, hey, you don't have probable cause to charge me with this. There's not documentation, there's not those pictures, you don't have witnesses to prove this case. There's not enough evidence, raise any constitutional issues. Everything should be suppressed. They just came on my property without a warrant. And we litigate those initial things in that pretrial process. Generally, there's at least one, if not 2 or more pretrial hearings. From there, if it's still not resolved, they're still not compliant, and they say, no, I'm not guilty, I did not violate that code enforcement, then it gets to the point of a trial. It's a misdemeanor level offense, so in Minnesota, on a misdemeanor, defendants have the right to have a jury trial in their case. So we bring in the community, we pick 6 jurors for a misdemeanor, and can have a jury trial, and that's the piece where that code enforcement officer is again important, because that's the key witness to come in to prove up the case, to lay that necessary foundation to get any photographs into the record, those observations that they made, possibly that initial complainant having to come in and testify about their observations, their reports, any statements that that defendant made. They can waive their right to a jury and just have the trial to a judge in a court trial, but that's the piece where ultimately proving up that they are guilty of this code violation to get that conviction so that they can be sentenced and have an enforceable order by the courts to require them to comply.
And what we should have done on that is put quotes around enforceable order. We are seeking more. We're seeking a sentence, as Alexis said, a sentence that says do something. We just had a criminal code trial on a truck parking case, semi-truck parked on property outdoors, over and over and over. I wanted his trial. We went and had the trial. It was basically what we call it in the criminal world is a long guilty plea. He got up and he admitted to everything. He said, but don't do that. It was just a waste of time. But it was an easy conviction, guilty, very quick guilty verdict. Judge's sentence, no same or similar, remain law-abiding, pay a fine. Okay. So now we've got a probationary sentence that requires somebody to go out and check. Community corrections isn't going to do it. You think cops hate code enforcement. Trust me, community corrections does not do code enforcement. So now you have your code enforcement official who is going to go document any new violations and then go back to your prosecutor and then bring a probation violation. So I say this not to say don't choose criminal, but just have eyes wide open as to the realities of it. We went through, we went to the mat, we convicted this guy. We got a conviction, we got a sentence that says no code violations. It still requires the city to have a continued investment in investigating this property and documenting violations and giving it to your prosecutor. So we can file a warrant to revoke probation and put him in jail, which still might not result in what? Compliance. So just remember, and we hope we don't get there. But when we have to take a guy to trial, that tells me this guy does not care what type of actions there are. So.
Yeah, so that next step after trial, as Joe alluded to, is sentencing. I don't know if I've ever seen a judge order someone into jail on a code enforcement case. So generally it's that state sentence. So they're ordered that maximum 90 days in jail. But they don't actually go to jail, they don't serve that time. It's hanging over their head as continued motivation, as a continued reason to try and get them into compliance with those conditions of, you're gonna be on probation for a year. You're gonna have to get in compliance within 30 days. You're going to have to pay a fine. Have no new ordinance violations within that next year. If you do those things, you don't go to jail. If one of those things happen, yes, we'll have to bring you back into court on a probation violation. Those 90 days are over your head, then we're gonna have to talk about what to do about it. Increased fines, community work service, possibly jail time. And so those are the types of consequences or tools that there are within the criminal prosecution after a guilty plea or after a conviction at trial. So what's required, there has to be that documentation. We have to know who the witnesses are, we have to know where to find them, we have to know how to be able to subpoena them to get them into court. We talked about having that one code enforcement officer. The more people that are going out, taking these statements, looking at these properties, are the more witnesses we have. It's the longer your trial will go, and it's the more city officials that you're gonna be paying in potential overtime to come in and testify in court. So photographs are important, laying that foundation of details of what are we looking at, why does it matter, and when did it happen, and where did it happen, so that we can get that in. And again, those witnesses, generally trying to keep that as succinct as possible versus having 5 different people each doing one tiny piece of the case. So what to expect? Time. It can take time to get the charges filed. It can take time, especially in this post-COVID world, to get a court date. It can take time to resolve the case, ongoing continuances. It can take time to find the defendant. If they don't show up for court, the case goes into warrant. As Joe mentioned, law enforcement generally isn't super focused on code enforcement, and those misdemeanor warrants have some restrictions that can be imposed on those as well. So if they don't show up to court, a warrant issues, and then they're just in the wind until somebody finds them and drags them into jail, get them that next court date. The system is in limbo then for however long that person is missing. There's control issues. We only have control over certain aspects of the case. We can't force people to plead guilty. We have subpoenas to force witnesses to show up to court by the time we get to trial. We can't force the court to give us timely court dates. We're at the minimum court administration what their dates are. Again, trying to educate judges about why these cases matter and keeping them moving forward in the midst of the domestic abuse and other things that come up as well. It could mean a trip to court for city officials, again, paying that overtime and the cost for multiple witnesses as well. And success can vary. You never know what a jury is going to do. They're completely unpredictable. It's a random 6 people off the street that are picked to sit in that box. So, you know, their neighbors have great lawns. They don't think it's a big deal if their grass is too long and they just want to go home. They don't want to have to sit there all day. So they could acquit, and you end up going through this whole process without a guilty verdict. So it's a little bit risky in that way, as you don't know where things will end up.
So just a very quick recap, and we're running out of time here, so I want to make sure we get through a couple of quick case examples and give a few minutes for questions. So what you're going to expect, civil, it's comprehensive. Cities shy away from civil because they think criminal is easier, but you're going to get a better, more comprehensible, and sometimes quicker result. It can be costly. I should have put a question mark. I think it might be more costly than criminal prosecution, but I don't always know that that's true. And we'll see in one of the case examples, civil can move very quick when it needs to. That means less attorney time, that means less court time, and less review time. Focus is on the property with civil. Again, to Tom's point, the property owner is usually the person you're targeting because they have the ability to control their property. Difference in prosecution, it's quicker to initiate. You can crank out a citation or complaint within 5-10 minutes, truly that quick. It can be less costly, but also less effective, and the focus is on the person. So when you're thinking, who am I trying to get at, the property or the person? In criminal, they have the constitutional right to an attorney, right to a trial, right to protection by rules of evidence, things like that. You're focusing on the person now and the actions that the things that they did, which means we can't usually. Remember my judge who just issued an order to go search the property? Judge, you can't do that. This guy has constitutional rights against unlawful searches. The property doesn't have any rights. That's the difference in criminal. In civil, we can issue all kinds of order related to that property. The property can't have certain things on it. So when you're thinking thematically, which one do I pick? Is it about the property or the person? It's almost always about the property. So what's the leverage point? Is it the person who's doing something? Is it the owner? Or is it just a condition that happens to be there, like a vacant house or something like that? So my quick civil case example. We got a complaint from neighbors. December to March is important because the ground's frozen. You don't really know if that substance is mud or something else. It looks like mud. Investigation complaints, you can't really tell, but they're taking this information. They finally determined it was emission from the subsurface raw septic effluent. Again, there's another phrase for that. April 16th, they finally confirmed that. I did this case. Motion, temporary restraining order. Said, to Tom's point, safety. There's kids. Next house over. This is a safety issue. You can't have this happening. It was served and an order granted the same day. We served it, turned it in. The judge gave that order that day. Water off. This was a tenant who had this issue, who wasn't doing anything, and the property owner. We served them both. And you know who did the work? Property owner, because he didn't know what was going on. He said, oh my God, I'll take care of it. May 4th, we gave him a hearing, and the judge said, I am continuing to suspend all septic use until this property is fixed. May 5th, CEO is reviewing ongoing communications like, okay, you've now got a contractor out. Your contractor's going to do X, Y, and Z. July 31st, they confirmed the septic system installed, stipulated dismissal. The property was fixed, problem solved. So that's about 8 months. In 8 months, we stopped it within less time. We stopped it in about 2 weeks once we could confirm what it was. But the problem was completely fixed in about 8 months. Your criminal case example, slumlord code violation. Tenants, non-English speaking tenants, their children are having bites on them. So we file a complaint. They document, there's some sort of infestation here. There's an arraignment hearing, look at that. This is pre-COVID. I would say that first appearance is certainly months later now, just due to the backlog in the courts. We have a pretrial hearing, another pretrial hearing because they didn't show up once. They get a warrant, they come back for another pretrial hearing. There's finally a plea hearing. We did re-inspection, compliance confirmed. This is one of the good slumlords. It's one of the good, he cared. He finally cleaned it up. We protected those people. It was kind of the same timeline. I'm just going to tell you with COVID, this is certainly going to be months longer. And then sentencing, and it was taken care of. Yes?
That infestation, like the tenants, how would that be a city issue?
It was an apartment building complex.
Okay.
It was throughout the building.
So the tenants came
yeah.
to...
And said, we've asked him to take care of it. It looks like there's, I mean, it was...
Got it.
Yeah.
Okay.
Infestation is a nuisance.
Okay.
Yeah. If you ever have infestation, that's gonna be a nuisance. Tenants will call them in. The other time where they often get discovered is if it's like a single family home, police get called on a domestic or some sort of disorderly, police are at the door, they observe inside and say, oh my God, come back and say, hey, we got some code issues here.
Okay.
That's almost always gonna be a nuisance.
This is
Okay.
the criminal example, by the way, I used intentionally because it's a case where when we talk about why we enforce code, when you've got children who have no ability to protect themselves, and you've got parents who don't have the ability to communicate things clearly, immediately, and urgently to take care of it, and are asking, please help, they have nowhere else to turn. So code enforcement isn't this sweep under the rug, annoying thing. It can have very real life consequences. And so that's my little soapbox. Remember, it's important to have process. It's important to document it. It's important to take notice and action because there's real life results for people. Sometimes it is as it is, and they have an emotional support rescue or rooster. I don't know, maybe. But sometimes it's really important. So my last is you got process, documentation, notice and action. These are your keys. And then can it work? Some of these don't necessarily look like violations, but there's a lot more to these properties than you might imagine. They don't look good. And this was a civil action that one of our cities took. And they cleaned up everything. It looks so much better. Your neighbors are happy. People respect the ordinances. The process works. So we're definitely over time because, hey, that's what you get for when you have 3 lawyers up here. Jack, do we have any time for questions? Yeah.
Yeah, you got 12 minutes.
Oh, perfect. Go ahead.
I got a quick one. How do you handle a situation of code enforcement when the person that enforces the code may be family or friends of the distressed property owner?
I mean, you got a conflict there. That person has to recuse themselves from the entire process. And then you gotta bring in somebody else, whether that's directly going with your city attorney, assuming your city attorney is gonna be related to somebody within your own city. Or finding somebody within the city, that can enforce it. Otherwise, if you're literally a small enough town that everybody's connected, you can hire outside and bring somebody in. And again, that's gonna be a little more costly, so you're probably only gonna do that in the most extreme circumstances. But absolute conflict of interest, interested individuals have to recuse themselves from the whole process, bring in somebody from outside to go through it when it calls for it. I mean, sometimes the reality is there's going to be code violations that cities are just going to let go. It just happens, and that, you just got to determine the severity and how much the city wants to enforce.
Thank you.
Yeah.
As the enterprise car rental commercial lady says, it sounds expensive. You've given us some good advice about the relative costs of these different options. Can you give us any thoughts about budgeting and how to think about that on an annual basis?
Well, it's going to depend on the contract that you have with your city attorney. Again, goal is always compliance. If you can get there without involving attorneys, great. I mean, we love to do stuff, but we're happy to sit back. So if you can do it without an attorney, great. Then it just depends on your attorney, and it depends on the stubbornness of the violating individual, because they can put up a fight and they can push back, and your attorney's going to have more and more time into it. Oftentimes, these types of actions by an attorney aren't going to be covered under a retainer agreement. You're going to be billing outside, so you're going to have to look at what the billable rate is, get an idea, the hours that are going to have to go into it, depending on how far along you go before you get them to compliance. It's really up in the air, but I mean, you can be looking, if you really fight it, you can be looking at 20 hours, pushing to 50 hours if you go through an appeal. So it's case by case basis, unfortunately. Look at that contract, talk to your city attorney, get them to give you kind of an estimate. But part of it depends on the other side that we can't predict, and how much that other side is going to be stubborn and make it more difficult.
And as from the criminal side, when I say it's typically cheaper, is our firm, certainly our prosecutors, we have contracts that are typically flat fees. We work out what the caseload is, what the volume is, we have flat fees, and so the city has some consistency. We know what the cost is. And that's great to help cities build their budgets and figure out what's going to be the best tool. The problem is the best tool is not usually the cheapest tool. You need a hammer, what's a cheap version?
No, I'm just looking at the section.
My metaphors about apart. That's a real time metaphor falling apart real time. What you want is the best tool, the right tool. And so you might have, hey, we can do something. Let's have our criminal prosecutor take it. We happily can do that. But we also have a very frank, candid conversation. The end game here is this.
All right.